On Thursday, 21st July, the UN Human Rights Committee adopted its 34th General Comment on Article 9 of the ICCPR, the right to freedom of opinion and expression. Professor Michael O'Flaherty was the committee member who drafted this General Comment and guided the committee through the process of its adoption. Mr. O'Flaherty, before we discuss the substance of the General Comment, perhaps you could explain a bit about what a General Comment is and its purpose.
Of course. For many years now, the Human Rights Committee and the other treaty bodies have developed commentaries on the articles of the various treaties that we call General Comments. These are detailed explanations of the application of the law of the treaty to the various situations in which the issues arise. It's not invented from the sky. It's not the committees making new law. It's simply distilling their practice over all the years as they've reviewed country reports, as they've considered individual communications, pulling it all together into a detailed document to give advice to states, to rights holders, to activists across the world on the issue they're addressing. We have just finished, as you say, General Comment 34 on Article 19, because we hadn't done a general comment on that article for something like 20 years. So what we did have was very much out of date. A lot has happened in that period with regard to freedom of opinion and expression, and it was high time to pull together our practice.
Thank you. As you said, you've addressed a bit why Article 19 at this stage. What do you think are the particular key issues that this General Comment highlights? This
General Comment covers a very wide range of issues. It's difficult to determine what is the key one, but for example, it expels out the breadth of what expression can be. It's not just speech, it's not just images, it's not just art, but it could be what you wear, it could be how you present yourself. This also could be, in given circumstances, a form of expression that's protected by Article 19. That's one interesting element. A second element is that for the first time in United Nations treaty practice, it spells out that element of the right that addresses access to information. Access to information is an important topic discussed at the national level in many countries. It gets some regional attention, but this is the first time the relevant UN treaty body has spelled out in any detail what it means to say there is a right of access to information held by the state. The General Comment goes to great lengths to explain very precisely the extent to which states may, and only according to these criteria, may limit freedom of expression. In more detail than has ever been done before, it addresses each of the elements that legitimize restriction. Restrictions have to be in law. What does law mean? We go to some detail to explain that. They have to be necessary. How do you apply a test of necessity? They have to be proportionate. How do you apply the test of proportionality? And so forth. And I think this will be of great assistance to everybody to measure whether the restrictions are acceptable or they are excessive. We deal with some very sensitive topics, contemporary topics of expression. For example, the extent to which freedom of expression protects the new media, the new information platforms, Facebook, bloggers, internet, email, you name it, the whole range of new communications, including video like this. And what we make clear that these are no less protected than the traditional forms of expression. The protections of Article 19 extend in just the same way to the internet as they do to a newspaper or to a journal. We deal with some of the issues that are attracting a lot of attention at the present time, such as blasphemy. The General Comment makes it clear that blasphemy is only tolerated within the very limited extent that it might be required under Article 20 of the Covenant on Civil and Political Rights. In other words, as an element in the duty on states to prohibit such forms of hate speech that are so extreme that they incite violence or discrimination. One other, by way of example, because it is a very rich document and there are many other points I could make, one other area that draws attention is that of what we call, or what are so-called, memory laws. Laws that dictate how the past may be referred to and what version of the story of the past may be promulgated. And the committee makes clear that in their extreme form, memory laws are in violation of Article 19 of the Covenant.
Thank you. As you said, this General Comment covers an awful lot of new and developing areas. Were there any issues that the committee found particularly problematic to find a position on?
Not really. It took 2 years to negotiate this general comment, but that's not because it was massively troublesome. It's just because great attention had to be paid to its elements, and also attention had to be paid to the submissions received from interested stakeholders. We've received, within something like 75 submissions, at least 350 drafting suggestions. That took a lot of time to work through, and it's very important to pay attention to what states and civil society are suggesting should be addressed in the general comment. That's the reason for the very long negotiation process. But in terms of the dynamics within the committee, it all went very smoothly indeed, and there was, I really wouldn't be able to point to any particular great controversy that would in any way suggest that there was a difficulty in finding common positions.
You said you received a lot of input from stakeholders. Is that a new development in the adoption of general comments, or something that's been done before? And do you think that level of interest shows that the committee was right to address Article 19 at this point, because it's clearly a popular issue, one that people feel is immensely relevant to our times?
That's a very interesting question, in the way you put it. It's not the first time the committee has asked for input, but the volume of input surpasses anything the committee has seen before. And perhaps that then answers your question, that the various stakeholders, states and civil society, thought it was worth the effort to put serious time and attention into commenting on the draft as it developed, and that's very welcome. And it's a validation of the decision by the committee to forge ahead with this general comment at this time.
Is there anything else that you think it's important to say about this general comment?
Well, I think the most important thing that I'd like to say at this point is that a general comment is only as good as the extent to which it is disseminated. Your initiative to do this video now is obviously a welcome step. I hope that others will take similar initiatives to promote awareness of the general comment, to use it at the national level. Ultimately, the general comment only has any value if it actually improves the situation of human rights for the rights holder, and that won't happen without really vigorous efforts by everybody to bring to the attention of the rights holder what are their human rights.
Thank you.
Thank you.